Her best friend of 22 years stole her dying mother's $340,000. She trusted her best friend of 22 years with her mother's dying wish. Then $340,000 disappeared, and so did the friendship. For more than 2 decades, the two women had been inseparable. They met in a community college accounting class in the early 90s, bonded over shared ambitions, and watched each other grow into the people they'd always hoped to become. One became a licensed financial advisor with a boutique wealth management firm. The other became a school teacher, a mother of 3, and eventually the sole caregiver for an aging parent. When the teacher's mother was diagnosed with late-stage pancreatic cancer in the spring of one year, it was the financial advisor she called first. Not a lawyer, not a bank, her best friend. The dying woman had accumulated $340,000 over a lifetime of careful saving. A modest home she'd sold, decades of pension contributions, a small life insurance payout. She wanted it passed cleanly to her daughter, protected, grown if possible. And so, with the financial advisor present at her bedside, a verbal agreement was made. The money would be transferred into a managed portfolio account under the advisor's firm. The teacher would be the sole beneficiary. It was, both women agreed at the time, a matter of trust. The mother died 11 weeks later. When the teacher reached out to access the funds 7 months after her mother's passing, she received something she hadn't expected: confusion. The advisor's firm had no record of the account. Internal records showed a transfer of $340,000 received, then dispersed, to where no one could say clearly. The advisor herself became evasive. Phone calls went unreturned. A single email arrived explaining there had been a portfolio restructuring and that the funds had been reallocated in accordance with the original instructions. What original instructions? The teacher had signed nothing. Her name appeared nowhere. She hired an attorney and filed suit. $340,000 in compensatory damages, plus $85,000 in interest and legal fees. Standing before the court, the teacher described watching her mother write down account numbers on a yellow notepad the afternoon the advisor visited. She remembered tea being made. She remembered her mother smiling. She remembered the advisor saying, "Don't worry, I'll take care of everything." Under cross-examination, she admitted she had never personally reviewed any documents. She had trusted. That was the entirety of her case, and it was devastating in its simplicity. The advisor's defense was methodical and, on its surface, credible. She produced a signed investment directive, dated 6 weeks before the mother's death, authorizing a charitable remainder trust. Under that structure, a portion of the estate would fund a designated nonprofit organization, with the remainder returned to the beneficiary over a structured period. The advisor argued the mother had wanted to leave a legacy beyond her family. She argued the teacher had known. She argued the document proved it. The courtroom shifted. The charitable trust documentation looked legitimate. It bore what appeared to be the mother's signature. It named the advisor's affiliated nonprofit as the primary beneficiary. The teacher's attorney had no immediate counter. For one long recess, it appeared the case might collapse entirely. Then a paralegal on the plaintiff's team found something while reviewing the estate's paper trail. A detail that had been sitting in a manila folder in the deceased woman's home office for months. It was a letter, handwritten, dated 4 days after the signed directive the advisor had produced. In it, the mother explicitly stated she had changed her mind about the charitable arrangement after a conversation that had made her uncomfortable. She had written to a different attorney, one she'd never managed to call before her health declined, asking how to revoke what she'd agreed to. The letter was never sent, but it was dated, witnessed by a neighbor, and it described the advisor by name. The judge reviewed both documents carefully over a 2-day recess. Her ruling was direct. The charitable trust directive was not invalidated. Its signature held, but the subsequent letter demonstrated that the decedent had experienced a change of intent under circumstances the court found inconsistent with transparent fiduciary practice. The advisor had never disclosed the charitable structure to the teacher before or after the mother's death. That omission, combined with the timing of the letter, constituted a breach of fiduciary duty. The court awarded the teacher $340,000 in full, plus $47,200 in interest. The request for additional legal fees was partially granted. The advisor's firm suspended her license pending a separate regulatory review. The nonprofit at the center of the case dissolved quietly within the following year. The two women have not spoken since the verdict was read. The teacher framed her mother's handwritten letter and hung it in her hallway. She has said in interviews that winning didn't feel like she expected it to. The money came back, the friendship didn't, which raises the question that no court can answer. When someone uses your trust as the instrument of harm, is recovering what was taken ever really enough?